and then welcome everyone for what should hopefully be a very uh, educative session for everyone to understand a couple of different nuances. The first one being where are the regulations frankly heading towards? I think a lot has already been spoken about COVID, the impact on fund management industry, but for fund cycles which are 8-year, 10-year products, so to speak, this can still be seen as a temporary phenomenon. It could have impact over a year, 2 years, and so on and so forth. There will be new normals that will emerge, but over a product which is 8-year, 10-year in length, there are some moves which are happening on a global basis and obviously also in India, which sort of far outflank the COVID and its related impact. With that, I think obviously while the session discusses on some of the recent changes introduced by SEBI in the AIF program, there are broader themes which are at play. The first one is that from the investors and fund managers perspective, let me break it into two segments. Investors or limited partners LPs are the risk takers because it is their commitments, it is their money which is going to be at play when the fund starts making investments. The fund managers or the general partners or GP in that senses could be perceived more like the risk assessors. While fund managers also tend to sponsor the fund, ultimately their role and the value that they add is maximum delivered on the basis of the kind of deals that are identified, the value add they perform during the tenure of the product, and at the same time finding meaningful exits, which is in line with the defined timelines or the fund term that they have set out right at the beginning of the product. So to begin with, in this equation of risk takers and risk assessors, the LP and the GP in the structure, globally the fund regimes have been designed in such a way that there is a distinction being drawn between institutional investors and non-institutional investors. Now, now in this case, if you imagine how India was till a decade back, we had on one hand the mutual fund framework, which obviously was more retail type in orientation. We had the portfolio manager regime, which till 10 to 12 years back allowed pooled sort of products also being offered. The portfolio manager regime became depooled only about 10 years back. And in the same bucket, you had the venture capital fund regulations, which allowed pooling in a basis where even 5 lakh rupee ticket size was encouraged. So obviously the regulations AIF program, when it was introduced in 2012, there's a gradual shift to sort of sophisticate the entire product so that a greater transparency can be imposed on the mutual fund regime, whereas the AIF regulations with a 1 crore ticket size was envisioned as a slightly more sophisticated audience look at product. Now, while the venture capital fund regulations largely relied on the HNIs, the ultra HNIs, or the family offices, and frankly, that was largely the case even when the AIs were introduced between 2012 2015. What has happened is that since 2015, a lot more has evolved on the AIF piece. Now, foreign investments can come into AIs without the need of any regulatory approvals or governmental approvals. AIFs have been given a very clear pass-through, and to the extent I'm speaking about the Category 1 and Category 2 AIFs. And moreover, the most important opening up was allowing and looking at each of the all the AIFs, irrespective of what is the color of the commitments that were raised, whether domestic or global. Their investments would be seen as domestic investments, depending on some of the qualifying parameters concerning ownership and control of the manager and sponsor. With these set of relaxations, liberalizations, or frankly clarifications, 2015, 16 and onwards, we have seen a huge amount of pooling happening for India allocation via the AIF module. We had initially seen the use of feeder type structures where global investors are involved, but eventually we have seen in a couple of recent vintages that global investors are actually quite happy to come directly into the AI format, with obviously the clarities on the tax side coming in. So what has happened is that now Indian fund managers are being benchmarked more against their peers in not just Southeast Asian countries like Korea, Japan, and so on and so forth, but also on the global funds where these investors are allocating. Because I'm sure a lot of the audience in would be aware that some of the largest allocators to Indian AIFs tend to be the GCC-based sovereign wealth funds. The Singapore wealth sovereign wealth funds have always been active, and also more recently, the Canadian pensions have also been coming in. What has happened is that because they allocate on a global basis, they benchmark the risk assessors, the fund managers also on a global basis, and accordingly, the fund documents already, even before the standardization circulars and clarifications were issued, were starting to look more standardized, more homogenized across the different funds which were sort of accessing the institutional capital. Now, here I would definitely like to add some of the recent market practices and uh, new terms that we have been seeing. Uh, while we definitely see a lot of insistence on the alignment of interest between the fund managers and the investors, we've also seen a lot of evolution on the management fees that is being charged. It is no longer the standard 2% which is like given. If you have institutional investors, there would definitely be some round of questioning that why is it not very close to the budget of the manager? Is this really a profit center, or is it something to just keep the lights switched on? We also see references to the previous fund. Are you getting the fees from a previous fund, and accordingly, are all the salaries and the key cost items already been taken care of? Or the moment you plan a successor fund, should we see a further dropping down of the management fees? And more importantly, could there be blended fees where instead of charging the 2% or 1.5 on commitment to begin with, then on cost of investments as you move down the fund term, could we see a blended rate of maybe 75 bips of commitments, 125 of investments, and so on and so forth, so that we try to drive a deeper alignment even in the management fees, which has traditionally been a key piece of misalignment. Uh, so here what we have seen is SEBI has definitely come back and tried to standardize some of the terms that investors had been asking for. To begin with, the audience may recollect that SEBI had already introduced the ask of making sure that the management fees and expenses and the carry allocation waterfalls are designed properly in the PPM, but also backed up by an annexure, which gives 4 or 5 different scenarios of profit, break even, loss kind of situations, so that the investors are aware of what the product cash flows are going to sort of look like. So, some amount of standardization was already coming in. It was merely a question of that how much more deeper would these standardization approaches get. It is literally horse before the cart, right? Like we allowed or we saw the industry to sort of prosper significantly from where it started in 2012, and it has already seen close to a decade year of vintage, so much of experiences from different fund managers who started, and so on and so forth. So obviously it was a question that, okay, we've allowed the industry to sort of grow. Now can we also see a qualitative shift? Can we also see that the PPMs being slightly more standardized so that the investors or the risk takers can understand what is the differentiation that the risk assessors are bringing by their different offerings? So that I thought was a fair summary of how we think the regulator may have been thinking, the kind of feedback that the regulator may have been receiving for something like this to evolve. So I think quickly jumping to the actual nuts and bolts of the standardization aspects, largely driven by the SEBI circular of Feb 5, where they asked that, okay, barring certain exceptions, we would want a more standardized approach to the PPM to be followed. We would want an annualized audit to be conducted, which would sort of make sure that the way the fund has been conducted is aligned to what was committed in the PPM. And the third aspect, which is slightly even more controversial, is around the performance benchmarking. Now, while standardization of the PPM and the audit is something which an AIF which has investors which are committing $10 million plus, and they are willing to sort of waive this ask, it can be done away with in some cases. But in case of performance benchmarking, there's no exception. I think so. With that, let me jump to the more technical side of the discussions, and here I will bring my colleague Blanche to the discussion. Blanche, I hope you can hear me.
Yes, Richie. Hi.
Great. Hey, Blanche. So, Blanche, the question to you is that while I did give you a broad overview of how we feel that the regulators may have sort of come through to this phase when they have attempted to, and it's a very fair, deep attempt to standardize a lot of stuff. What are your thoughts on the template PPM that has been issued by SEBI? And since you advise so many fund managers, across the different phases, those which are raising a first time fund, those which are raising, let's say, a second or a third fund, series 3 fund of sorts. What are the concerns that you have seen with the introduction of the template, and what is the feedback that you've been getting? Your thoughts on this?
Yes. Thank you, Richie. I think to begin with, just as you rightly said, the template PPM has been viewed as the regulator now having a more focused approach in terms of the information and commercial terms sought to be offered by a manager. Having said that, we have seen concerns primarily due to the detailed information that is now required to be provided under the PPM. And this is concerning because the AIF regulations were primarily created with the intent to introduce funds alternate to public markets with sophisticated investors and a high ticket size. And therefore, such sophisticated investors could conduct their own due diligence at the time of participating in the fund. Which is why the AIF regulations are light touch, barring the governing mechanisms and reporting requirements postulated therein. However, the template PPM goes into more granular details regarding the commercial items, and not just in terms of coverage, but also in terms of the discretion that the manager would like to provide to its investors. Secondly, we've seen that generally jurisdictions do not have the concept of a PPM, and even those jurisdictions that do, such as Mauritius and Singapore, for example, the regulators haven't gone ahead and standardized the information required under the PPM in those jurisdictions. And this is because the PPM is a marketing document. In effect, that it is the first document an investor is going to see when it showcases interest to participate in a fund. Until now, and even globally, managers have had the flexibility to hold the pen on this document and to showcase this marketing document and their capabilities surrounding the same. What the template PPM does now is that it takes this marketing document and the flexibility of managers and turns it into a kind of question answer format. And it also requires information from the fund managers, which they may not be able to anticipate as on the date of drafting the PPM, as these commercials evolve during the process of fundraising. And I will go into this in further detail. And B, there are some commercials which the manager may have not even wanted to provide in the PPM, but by virtue of this template, they are now required to. For example, a first-time manager setting up, let's say, a Category 1 or a Category 2 AIF, primarily with HNIs, may not want to provide, let's say, a key person clause or a co-investment clause. Had this been in the older format, the manager would have just omitted this information from the PPM. But now, by virtue of the template, SEBI's guidance note says that each commercial item under the template has to be mentioned, against which you either provide the information or you write the terms not applicable. What this could result in happening is that an investor who looks at the PPM may bring up a question or may question the investment manager as to what is the commercial intent behind not introducing this commercial in the fund. And therefore, negotiations between investors and GPs may become a much lengthier process. Having said that, the template has also been viewed by first-time fund managers as helpful in terms of the information that an investor would like to seek at the time of fundraising. Hence, just on an overview, while SEBI may have introduced the template PPM with the intent to, enhance disclosure of information, this has caused some concerns in relation to whether this could be an attempt to regulate even the commercial terms that are sought to be provided by fund managers. Richie?
Sure. No, that is very helpful. I think now this was a two-part question to you. I think the second part, and let me sort of give some background to this. We have seen that SEBI, in some of the current applications that we have been pursuing with them, especially on terms that you just mentioned, like, okay, if a first-time fund manager is raising, and let's say for certain reasons, some commercials are not intended to be offered, or let's say an institutional fundraiser is going on where the institution is backing the manager and the management team, and they wouldn't want to identify a key person from a get-go. Then in those cases, having these placeholder terms where even though you're not offering maybe some keenness from SEBI to specifically state that, okay, it does not apply, or this is not something which is intended. I think then what it does, it's slightly counterproductive. The manager would not have even wanted to sort of bring that into the discussion, and yet it is right out there in front of everyone. So given that, the question to you is that the more regular format of the PPM, which frankly evolves out of several rounds of negotiations with investors. And that is again going back to the earlier statement that initial funds were more HNIs and family office oriented, where negotiations were literally absent. Whereas all the most of the recent fundraisers we have seen have had a very healthy combination of domestic as well as institutional and overseas capital as a mix. So there obviously the discussions have sort of come together in the PPM, and accordingly the expectation that each of the points be mentioned and so on and so forth in the PPM. So how do you sort of balance the two? So what are the concerns or what are the aspects that you thought were there in the regular format of the PPM versus the new format, and what are the issues that you faced in the different applications?
So on a perusal of the template, there are various sections that we see which are similar to what we have in the older format. So just to go through the table of contents of the templates that SEBI has provided, it starts off in a very similar manner where you go through the executive summary, you provide the overview of your fund terms, you go into the business section, such as the market opportunity and the objective and strategy, and then you go into the meat of the document, which is your principal terms, and thereafter the conflicts, the risk factors, the legal and tax considerations, followed by the illustrations. So in terms of the form, it does follow the same as the older formats, but then when we go into the substance, we see much more detail. Separately, there are also new sections that have been introduced under the templates, such as the track record of the manager, which goes into complete detail of previous funds that the manager has managed. And in the case of first-time managers, they have to specifically mention that this is not applicable to them. Similarly, there is a new section in respect of principles of portfolio valuation, which earlier may have just been identified as one of the fund terms, now has a separate section with detailed information required to be provided there. So on an overview, while the form is largely in line with what has previously been followed, the substance does go into much more detail. Now, going into each of these sections or into each sticking out items per se, some items are a welcome move, while some have been viewed as concerning, as the manager may not be able to estimate these commercial terms as on day one of drafting the PPM. For example, if we go into section 1, that is the executive summary, on page 10 of the executive summary, we see the indicative timelines to be provided for subsequent closings. Now, this is an item that may not be plausible to be provided as at the time of drafting the PPM. And this is because a manager can estimate the first close and the final close, but determining subsequent closings as on day one is not possible because this would depend on various factors, such as the manager's ability to source capital, negotiations, the political climate, and in probably this instance, a pandemic where managers may not be able to source capital. So this is something that is subject to change as the fundraising cycle evolves. And in the event that a manager provides a certain timeline and shifts from it at any point of time, he will first require to amend the PPM and then move on with negotiations. Also, this is not really a disclosure item as the overall raising period is already mentioned in the PPM. So this is one item. Moving on to probably section 3, which goes into the investment objective and strategy. On the first page of that section itself, on page 13, the template requires the managers to provide the exact percentage allocation in each security, sector, and geography. Again, this is something that is subject to evolve over the fundraising cycle, and managers may not be able to estimate this as on day one because this is largely dependent on the availability of conducive portfolio opportunities. Separately, if we move on to section 5, which goes into the governance structure on page 16 of the template PPMs, under the headings of the trustee and investment manager, what is required is a list of responsibilities to be provided, which the trustee has under the trustee and which the trustee delegates to the manager under the investment management agreement. This has been seen as a welcome move because how it generally works practically is that the investor will first be given a PPM, and once they show more keen interest is the stage when they're given the remainder of the fund documents. Now on day one itself, when the investor views the PPM, the investor will be able to see the allocation of responsibilities between the two fund parties, that is the trustee and the manager. So this has been seen as a welcome move. Similarly, Section 7, which goes into the track record of the manager, as I mentioned, this is a new section that has been introduced by SEBI under the template, is a good section as it provides investors with enough information to assess the capabilities of fund managers and their investment teams to manage the assets of the fund. A main point under Section 7, which is the meat of the document, that is the principal fund terms, a main item is item 39 on page 32, which goes into side letters. Now, this is the first time SEBI has acknowledged a side letter right under the PPM document. However, it doesn't just cover side letters as a whole. It also goes into a step further in providing certain criteria. There could be cause of concerns here because primarily SEBI requires the manager to provide the investor criteria basis which the manager will provide a side letter, right? And this can differ because as on day one, a manager may anticipate providing side letter rights only to a certain ticket size of investors. But moving on in the course of negotiations, a manager may, due to a healthy relationship with an investor, decide to provide them with a side letter right. So this is something that's subject to change. Similarly, the template requires managers to list out each of the commercial terms basis which side letter rights will be offered. Again, something that cannot be determined as on day one because this is largely subject to shift depending on the course of LPGP negotiations. Another item where when I mentioned that the regulator is being viewed as regulating commercial terms sought to be offered by the manager is seen under the list of prohibitory items which a manager cannot offer under a side letter. Now, these are mentioned under 4 bullet points, the details of which the regulator does not go into, 2 of which are understandable and have been followed just from a good governance perspective. Primarily, a preferential exit from a funder scheme is generally not given to investors. And similarly, a give back item, which is maintained as the same for the entire investor base. 2 items which are slightly unclear is primarily contribution to indemnification. Now, indemnity in relation to indemnification of fund parties is something which is not drawn down from the investors. So it's unclear as to what the regulator means by contribution to indemnification. And similarly, another item which a manager cannot provide under a side letter is drawdowns. Now, this could be viewed as this is again unclear because drawdowns, whether they mean drawdowns in relation to the timing of the drawdown or the schedule of the drawdown. I say this because certain institutional LPs, depending on their own internal policies, may require a more detailed drawdown notice from the fund manager, which the manager, for its own commercial reasons, may not want to provide to all the investor base. So this is generally a side letter right that is given to that specific investor. So in terms of the side letter provision, maybe they could have gone into more detail under the prohibitory list, but this is largely the items that stick out under the new template PPM. I think just to summarize, it's understood that SEBI's intent was to provide more disclosure of information. However, there are opinions that this could have been done with guidance notes on the information to be incorporated as opposed to a mandatory format. Having said that, it's also viewed as helpful in terms of the kind of information investors would like to see in a PPM. So that's about it. Thanks, Richie.
Thanks, Blanche. That's quite detailed and incisive. And obviously, a lot of experience is evolving. I think
Yes.
not just with the practitioners and the fund managers, but also with the regulator. Today, they are following the template in a very hard-coded manner. I'm sure with more feedback, I think there will be some experience building at both ends, including with the regulator, and hopefully some of these edges would get softened and smoothened out. I think with that, we perhaps we can now move to the second piece of the SEBI circular on the standardization aspects that was to do with the audit that has to be carried out. I think here again, and here I would like to bring in my colleague Shivam to the discussion. So Shivam, we have seen that there is now an expectation from SEBI that the manager sort of carries out an audit, and by and large, the audit seems to be focused more on the commercial sections of the PPM, which is the term sheet. Uh, so again, what are the audit requirements that the SEBI has imposed, and where do you see this coming from, and what's your experience so far?
Thank you. Thank you so much, Richie. So SEBI had initially proposed this audit requirement via its consultation paper, which was released last year in December, basis which the circular on February 5 came out. So the circular states that the audit has to be done on an annual basis, and the scope of the audit has to be that the AIF is complying with the terms of the PPM. So to start with, I would say here that while the consultation paper said that the scope of the audit has to be the compliance with the terms of the PPM with a special focus on the side letter impact on the other investors. However, we did not see this coming along in the final text of the circular that came out. The final text of the circular only says that the audit scope has to be compliance with the terms of the PPM. Now, moving ahead, a report, the, the report of the audit has to be submitted to the manager, SEBI, and the trustee. Trustee in case the AIF is set up in the form of a trust, and of course, designated partners in the board in case the AIF is set up in the form of an LLP or a company. Now, there are some issues which we have identified out of this audit requirement. One is that while the text of the circular says that this audit has to be carried out by either an internal or an external auditor, Section 5 of the standardized PPM states that this audit has to be carried out by an independent auditor. So there's a gray area that whether this audit has to be carried out by an independent auditor and who this independent auditor can be, whether that it can be an internal or an external auditor. So it's hard to imagine a scenario where an internal auditor will be an independent auditor. While the consultation paper on this said that the audit to start with will be either internal or external, and going ahead, it will be only external. We did not see this also coming along in the final text of the circular. Now, I would also like to say here that this audit requirement is in addition to what has been already contemplated in the AIF regulations under section 22 E of the AIF regulations. There is already a requirement that the manager should disclose any breach of the compliance with the terms of the PPM to its investors. So what was traditionally an LP-GP relationship has now been, interfered with a third-party auditor coming in, which will now be giving its reports to the board, etc. Now, moving ahead, I should also say here that this audit requirement here is increasing the costs of the AIF. And having said that, there has been industry feedback that how this audit requirement has to be carried out for existing AIFs. So while the standard, there have been various carve-outs that the sections which are not to be audited, as you rightly said, that the focus is on commercial terms of the PPM. The circular says that the risk factors section, the legal, regulatory, and tax section, and the track record of the first time manager section are not to be audited. So here also there is a confusion that how the audit will be carried out for a non-standardized PPM, because the nomenclature of sections may be different, the form of the sections may be different. So we don't know today as of yet how a audit of a non-standardized PPM has to be carried out. So a clarification in this regard is it will be highly appreciated from SEBI, and all the investors and of course the industry is looking forward to it. Over to you, Richie.
Sure. Thanks, Shivam. I think with that, let me also bring some respite to the audience by trying to understand what are the situations in which there could be an exemption from these audit requirements that you just summarized, or the templatized PPM approach that Blanche had spoken about. So, Nandini, I think could you give us some understanding on these exemptions, and when do you see that trigger, and what's the latest on that?
Thanks, Richie. And I hope I'm audible. The network is very bad
No,
today
you are,
for
you
me.
are, you are.
Okay,
Absolutely.
great.
That's fine. Yeah.
Great. Also, the light is fluctuating. This is not my normal room setting.
We'll manage. We'll manage.
Okay, great.
Yeah.
So yes, there are exceptions to this, to both these requirements. SEBI has prescribed a waiver, not really prescribed, allowed for a waiver in case of angel funds, which is a subcategory of Category 1 VCFs under the AIF regulations, and AIFs in which each investor commits at least 70 crore Indian rupees, or if it is a non-INR fund, then at least 10 million US dollars or equivalent. So if these sort of criteria are satisfied, then you can opt to waive out of the standard format of the PPM, as well as the annual audit requirement with respect to the PPM. Now, my only concern here is I think it's clear who can waive and what can be waived. What's unclear from the format of this waiver letter has been provided in the circular is when can the waiver be exercised. Now, let's just look at different situations, right? Today, I am drafting my PPM to market my AIF to potential investors. At the time of drafting of the PPM, it is an unfair expectation of me to actually determine whether I will have each investor who is above 70 crore or at least at 70 crore. They will in fact provide me a waiver letter despite having that kind of a commitment. Third, how can I today go ahead with a draft and tomorrow be required to change it because 4 out of my 5 investors waived it, but one investor did not. So if you look at the format of the waiver letter, it actually talks about a prospective investor. The language of the waiver letter, and I quote, it says, we are considering to invest in the AIF managed by so and so. So before even looking at the PPM, I am required to sign the waiver letter. Whereas in order to even consider an investment in the AIF, I would like to look at the PPM. So it's kind of circular in that respect. Also, if you look at the funds which are existing, so funds which have maybe undergone a few raisings and have some more raisings left, or have say undergone the final closing but are in investing mode right now. So there are questions as to whether audit will be applicable to these sort of funds, whether this standardization will be applicable to these sort of funds, and there is a fair lack of clarity in the circular, but we understand from SEBI that perhaps uh, existing AIFs who have already got registration with SEBI before March 1, 2020 need not undergo these processes of standardizing the PPM, but might still require annual audit, which is where I think Shivam discussed how auditing of older versions of PPMs could be a bit problematic because the template PPM only requires certain sections to be audited. That was second. Third was I just have some views on the circular overall, which I thought I'll briefly share. Basically, basically there was I think the intent of the circular was to allow for uh, disclosure in a symmetrical and in a consistent manner by different AIFs. What happened as a consequence was the PPM was misunderstood to mean only a disclosure document. The marketing aspect of the PPM was forgotten. So it's a mixture of two, right? Uh, if and SEBI did not have to look far actually to provide this sort of a template, because if you look at other investment vehicles like REITs or InvITs, which are actually listed products, these regulations have also have a requirement of drafting the PPM in a particular manner, but the requirements there are only in the form of principles or concepts that need to be followed. So they are actually a schedule to the InvIT and REIT regulations. These are infrastructure investment trusts and real estate investment trusts. The PPM for these products are required to be drafted following those principles, but in no particular template, order, or form, which I think could have been an approach that that we can follow for AIFs as well, given that AIFs are not even listed products to begin with. So so yeah, that those were my 2 cents on the circular other than what has been covered so far.
Sure. So thanks, Nandini, for that. I think here, let me definitely quickly acknowledge the role that IVC has played in this entire exercise. I think it's the maximum we have seen in recent times that the regulator take a lot of feedback from the industry, and how IVC has been able to concentrate a lot of those feedback. And then we see a lot of that in the way the circular was drafted, the exemptions that were carved out, and Nandini sort of summarized, and also some more exemptions and relaxations that the feedback that the industry is giving via IVCA, where I think some clarifications expected are maybe an explicit confirmation from SEBI that all the AIF related parties like the manager, sponsor, the employee welfare trusts, and so on and so forth, let those be identified as exempted from the investor ticket size of 70 crores otherwise identified. The second piece was that could we reduce the threshold itself of the ticket size to 5 crores, because again that is sophisticated enough, and obviously you have family offices which are quite discerning today, and that's the reality of the times, that even a 5 crore ticket size should be seen as sophisticated enough, and the threshold be reduced. But I think again it's like, let's look at the experience in the couple of years once this has been rolled out, and maybe the thresholds could be reduced as we go along. I think with that, let me quickly jump to Shivam and Shivam, quick feedback on this. On what about the performance benchmarking that has been now been put in by SEBI? And have you seen any concerns on this entire benchmarking threshold? Basis feedback that you're getting from investors on how they have seen it in some other markets. So could you just give us a quick couple of minutes of snapshot on this?
Yeah. So sure, I think at the start of the session, you introduced that the rationale behind introduction of performance benchmarking is to have a comparable benchmark where fund managers can compare themselves with their peers. And this is specifically for investors to, make an investment decision and compare AIF as a product with other investment avenues. So I will just introduce today that how circular has contemplated how particular benchmark will be created. So it has been the circular states that any association which represents 51% of the AIF will designate a benchmarking agency, which will then come out with the proper guidelines how to create this benchmark. So to create this benchmark, all the funds which have undergone their first close and have had their first close and a time lapse of 1 year has been passed from that first close will have to give all the information of their investments to this particular benchmarking agency, and then this benchmarking agency will come out with a particular benchmark. Now, going forward, the issues that we have seen with this benchmarking being introduced is that the circular states that when reporting, when an AIF is reporting to its investors the particular performance of its fund, it has to uh, it has to give the particular report which this benchmarking agency is coming out. So benchmarking agency has two jobs. One, it is creating a benchmark. Second, the benchmarking agency also comes out with a performance versus benchmark report for every AIF. So when an AIF is reporting to its investors its NAV, it has to also provide this particular performance versus benchmark report to its investors. So the circular today is unclear that whether this report has to be provided to all investors or only to AIFs. Only this obligation is on AIFs which are also comparing their performance with a particular benchmark. So that is one. Now, how so this performance benchmark has particularly serious implications for global fund managers who are looking at India for the first time and have no track record of investing into India. So the circular states that global fund managers who have priorly invested into India should give the details of all their investments into Indian companies to SEBI while they are seeking registration as an AIF. So today we expect that going forward, this benchmarking and performance versus benchmarking report will be an important criteria for investors while choosing whether to invest in a fund or not. But however, for global fund managers who have never looked at India, this particular report will not be available. However, but for managers who have been investing in India, this report will be available. Now, globally, what we have seen is that EU primarily, we all know that EU is going to discontinue LIBOR from December 2021. So they have primarily been looking at benchmarks, various benchmarks which should come out, and instead of coming out with a benchmarking agency, they have a proper benchmarking regulations which are there to regulate these benchmarking agencies and the guidelines prescribed therein. So that's about it, Richie. But where we have been receiving feedback that it is difficult to compare and for investors also to market your fund basis the only performance benchmark, because an investor doesn't only look at performance but various other things as well. So this can also be compared as, you know, standardization of how investors look at funds.
Right. No, no, of course. Thanks, Shivam. I think to quickly wrap up that point, obviously, when there are global asset allocators, I spoke about sovereigns that invest, the pension funds that invest. Obviously, if they compare India to something like Korea or Japan or China, I don't know if it's still on the radar of some of these investors. Then obviously the DPIs and a effective comparison between different funds would help them take a call that okay, for the risk, what is the sort of the risk return profile they're looking at. So I think with that, let me quickly jump to the other side of the equation. We only spoke about the LPGP, the risk taker assessor situations. Quickly jumping to the investment side of things. I think here I'll bring in Parag. Uh, Parag, I think while I did mention that COVID could perhaps be seen as a 1 year, 2 year phenomenon, and obviously speaking more from a GP who would want to sort of sell a bright picture to the LP that look here, this is our track record, this is what we have done, we are cycle tested. We have seen so many different vintages that if you're deploying over 3 year, 4 year period, then a COVID can actually give more interesting opportunities. Having said that, COVID definitely did have a lot of impact the way we look at it. I think from a portfolio perspective, the more I speak to some of the GP clients whom we work with, I think any portfolio that had logistics or physical gathering of people sort of as part of the thesis, clearly those businesses have seen a drop from where they were to literally about zero. So obviously there are strategies which are coming up, new business models being aligned. Maybe there are changes in behavior of the consumer and so on and so forth that will be factored in. But I think coming to the more serious regulatory reactions that have come about, which perhaps may be COVID driven, which perhaps may be slightly longer in the making, but eventually it got timed with COVID. So with that, perhaps Parag, if you could share with us your sense of where the press note 3 is, a brief summary of what the press note says, how does it impact the industry, and where do you see the industry today on that issue?
Thank you, Richie. And as you rightly said, while COVID has had a significant impact on the whole fundraising activities, it's not completely stopped, because there are certain industries which you also mentioned. There are new business models coming up. Existing business models being tweaked. To service the customers in these times, because the requirements are still there. It's just that how to serve the customers and run the business. So definitely investors have become very, or during, at least during the time when the lockdown was completely full in force, the deal making activity was actually very slow, but things are picking up now. When as the economy is opening up slowly, even deal making is picking up from our perspective as well. uh, the issue that actually PN3, and I'll just brief, because we're running short of time, and I'll briefly touch upon what PN3 did, and I think most of our audience will be aware of it. Basically what PN3 did was, it restricted investments coming in from countries which share land borders with India. When I say restrict, it's not ban. It's basically any investment coming from these countries should be subject to government approval. The prime target here obviously being China, because a significant amount of investment that comes from the neighboring countries is from China. Through multiple ways, especially in the technology sector, in the fintech sector, we have seen a lot of activity from Chinese investors. Right now, what the PN3, the restriction it places is that any person or entity which from these neighboring countries, or if the beneficial owner of any investment resides in these countries, invest in India, then you need to go to the government and take approval for that, right? So basically, at a level, it prohibits, because of the use of the word beneficial ownership, it prohibits both your direct investments and even indirect investments get prohibited. So even if money from China is being routed through some other jurisdiction, if it is coming into India, then by the plain reading of the regulations, such amounts cannot be received in India without seeking prior approval of the government, right? However, as I said, because beneficial ownership is not defined, it has actually led to a lot of confusion in the market, on what is the intention behind it, and what is the threshold that we need to look at in order to decide whether beneficial owner of a particular investment resides in China or these neighboring countries, right? We have few benchmarks under the current regulations in India, where a beneficial ownership, a significant beneficial ownership, ultimate beneficial owner, can be determined. So two most popular thresholds used here are, one is under the Companies Act, which talks about a significant beneficial owner. But that threshold talks about that if a company has, or if an entity or any person holds more than 10% in an Indian company, then you need to see who's the ultimate beneficial owner of that entity, which basically goes into the control test of more than 50%, unless such control is exercised through some agreements or contracts.
Right.
Right now, another definition that is there is under the PMLA regulation, which is prevention of money laundering, and even RBI has a master direction on KYC, for the purposes of doing know your customer checks for Aadhaar, etc. purposes, where the threshold is slightly different, where the unlike SBO, where you have to have 10% shareholding in the Indian company, the shareholding in the Indian company is not relevant. What becomes relevant is the intermediate company, which is the shareholder of the Indian company, what is the controlling interest held by someone in that entity, right? So how PMLA and KYC directions look at this definition is, for a company, they say, if anyone holds more than 25% of the share capital or voting rights of that entity. For a partnership, it's 15%. So depending on the nature of the entity, they have prescribed certain thresholds there, and if those thresholds are met, then if the person is considered as a beneficial owner of that investment, or whatever is the purpose for which you are determining the beneficial owner, right? Now, see, India is actually not unique in coming out with something like this. There has been a kind of anti-China sentiment across the world. Even our government is saying, that this is something not new. It was always in the making. It's just that the timing of it is that it came out right now. And interestingly, what has happened post this, the whole tussle in Ladakh, with China, probably is making things worse, at certain level, right? But the one thing that I want to point out here is, and as I was saying, sorry, that other countries have also come out with similar restrictions on investments from China. But there is one key distinction, that I would like to draw out upon what other countries are doing vis-a-vis what Indian government is doing. The way the law stands right now, if you see how US has, restricted these investments, or Australia, or even EU is planning to come up with some sort of restriction, there are certain thresholds which are prescribed, right? So what they are looking for is, first of all, it should be, in certain cases that they are looking at sensitive sectors, the ownership, or important key IP should not pass on to companies from China, or there is a state control test, that approval requirements, etc., are coming into play only when a entity investing from China has a state connection, right? Either state owned or has some sort of a state connection with the Chinese government, right? On the other hand, India has put a blanket ban on any investment from China, direct or indirect. While there's nothing wrong in it, obviously national interest has to be kept in mind while formulating your policy. But one area where unfortunately which has had a significant impact because of these restrictions is our investment industry, right? Because typically if you see also the preamble that came around along with the whole press note 3, right, spoke about basically prohibiting opportunistic or hostile takeovers or acquisitions of Indian companies, right? So you need to read a preamble to understand what is the intent behind the law, and the intent seems to be that control should not pass on, control of an Indian company should not pass on to these entities, right? However, the wordings paint a completely different picture, right? So, because if you see it from a fund's perspective, right, typically, the how, and as you initially mentioned, it's a GP-LP structure where GP, basically taking all the decisions with respect to the investments, and LP is only contributing the capital for that, right? In our view, if the GP of a particular fund, is based in a jurisdiction where India can receive funds from, like for example, US or Europe or some other jurisdiction, and if they have some amount of Chinese money, right, as long as the decision making is with a person who's or an entity from any other jurisdiction, it should not really have an impact. Because first of all, most of the VC investments, etc., if you see, don't really get into the control aspect of a deal, especially in early stages, right? There are minority investments of 10-20%, approximately, maybe going up to 30% in certain situations. But they still completely rely on the Indian promoter to run and operate the company, where they are not really getting into the whole decision making aspects of it. And even if you say that maybe because certain PE funds act differently, where they acquire controls of the company, etc. But again, here you need to see, even if a PE fund has acquired control of a company, who's sitting at the back, right? Who's the decision maker of that investment, right? Whether the person is from China or any of these neighboring countries, or from any neutral jurisdiction, through which India has no issues receiving foreign investments, right? So I think that is a very, very important distinction, that, and hopefully, we all have been waiting for a clarification for quite some time. Hopefully it will come soon. And the funds, especially the blind pool funds where the GP has no connection with the China or Hong Kong, uh, uh, should get excluded. Originally I mentioned Hong Kong because originally there was some thoughts around that how Hong Kong should be treated differently, because we have a separate tax treaty with them. Hong Kong has a separate WTO membership, etc. So the governments worldwide look at Hong Kong very differently. But after the whole Security Act in China, where Chinese increasing their influence on Hong Kong, I think that argument, we're losing that argument slowly, right? Because the whole independence of Hong Kong is itself coming into question, and its decision making abilities, right?
Right.
So that's one issue that we faced. Now, as I said, deal making hasn't stopped completely, and because of the lack of clarity, we had to do a lot of brainstorming on how to factor these in while working on the deal, on the documents for the deals which are ongoing. Because see, unfortunately, while the requirement for obtaining any approval, etc., is typically on the Indian companies. Here Indian companies are completely blindsided because they don't really know the details at the back end of their investors, right? So a lot of negotiations, discussions have happened where companies asked for representations, indemnities, etc., from the investors, right? In certain cases there were exclusions built in where companies said, while we are okay indemnifying you for everything else, if there is any loss that the investor suffers, let's say tomorrow the government comes out with a notification saying, we are looking at a 15% threshold, and they don't make any exemption for funds, right? And in certain cases, because the RBI has that 25% threshold, a lot of AD banks also, we have seen, are taking that threshold and seeking a declaration around it and going ahead with the investment. Let's say tomorrow government comes out with a notification of 15%, where hopefully will not happen. There may be some compounding or minor penalties imposed because of the whole lack of clarity. But worst case situation, let's say if they ask to unwind the investment, as a result of which any loss is suffered by the investor, the companies are very clear that here we will not indemnify you, right? So from this perspective, it becomes very important for an investment manager or for the fund, right, to seek legal clarity before making an investment and giving any declaration, because each fund is structured differently, right? So we have seen situations where when the funds discuss the whole ownership, etc., with us, we were very comfortable. Though there was minor Chinese exposure, we thought that should not come within the ambit of these regulations. But there were certain other cases where there was certain ambiguity because the amount of Chinese investment or control, right? So I think it becomes
Right.
very important for the funds to do that. And even while the original notification restricted only FDI in this sector, unfortunately RBI has started seeking details from AIFs as well, on their any money that they have received from Chinese LPs, right? Which pure reading of the law should not be the case, but looks like the government is still working through these regulations and coming out with details. Because if you see, right, historically, or in the sense that from an AIF perspective, as long as the investment manager is Indian owned and controlled, right, any investment made by that entity downstream is not considered as foreign investment.
Right. So, Parag, I think I'll quickly dovetail on a couple of questions there and one-line response from you. Okay.
Yeah, sure,
So,
sure.
so from a foreign inflow perspective, when foreign investments come into an AIF, there is a declaration required by the banker, which is receiving the remittance in India. The second point is that when units are issued to an overseas investor, there is a form INVI that has to be submitted. And when if the manager sponsor is foreign owned control, there's a form downstream investment DI which needs to be submitted, and then there is this annual FLA which gets submitted.
Correct.
No touch point till date refers to PN3 so far in our experience. Having
Yes.
said that, the question to you is that there are three touch points on an AIF from a foreign investor perspective. First is foreign money coming into AIF, simple as that. Second piece is foreign ownership of the manager sponsor. The third piece is even though foreign ownership control of the manager sponsor is non-Chinese or non-neighborly country in a way,
Hmm.
uh, would at the time of downstream investment some color come in, because downstream investments by an AIF foreign owned control still require the form DI submission.
Correct.
So would you, in your reading, and it's a one-line answer from you, would you, in your reading of how the PN3 has been introduced and the different amendments to law, take a view that the PN3 to begin with is not geared towards AIF type situations?
That's right. The way it's drafted, it's specific because AIF is covered in a completely different schedule, and these changes were made only in the FDI schedule.
Right. Thanks, Parag. And with that, I think thanks to all the participants. I hope you had as much, fun in the session as we had on the panel. We have attempted to cover a more broader sort of scope of questions that were posed. We have been in parallel keeping track of all the questions that have been populated. What we have also undertaken is that during the course of the weekend in the coming week, we will attempt to sort of reach out to most of you and respond to your questions. Obviously, there are some granularity involved in each of the questions, which frankly is beyond the scope of a session where we wanted to cover a slightly broader theme of issues. With that, I would like to conclude by saying that I think the SEBI circular is in a right direction. To begin with, the industry has definitely grown over the last decade. Insofar as the number of AIFs are concerned, I think we are already close to 600 AIFs already. Now it's also a question of the regulator coming in and making sure that there's a qualitative progress of the offering. Globally, we have seen investors or frankly regulators looking at mis-selling of product as a big issue. Now, mis-selling of product has been approached differently by different regulators, by regulating the manager, by penalizing the manager, or perhaps an approach that SEBI seems to have taken on making sure that everything is accurately disclosed in the PPM, which is what SEBI considers as the marketing document. Having said that, is it a move to remove the flexibility of the fund manager? Answer perhaps in the regulator's mind could be no. The attempt could have been to make sure that lot more becomes disclosable, which the manager in their own discretion may feel is not required. But at the same time, perhaps the investor did need to know whether something is the case or not right at the time when the product was sort of introduced to that investor. With that, I would like to conclude the session and hand the control back to Khaled. And we thank each and every one of you for making time in the middle of the day over the weekend. And we will definitely try to get back to you on the questions that you have posed. Thank you. Thank you so much.